the Superior Court of Fulton County, State of Georgia versus the defendant. Order on motions to recuse Judge Glanville.
This case is before the court to consider various motions to recuse, including 1. Defendant Diamante Kendrick's motion to recuse Chief Judge Ural Glanville, filed on June 12, 2024. 2. Kayla Bumpus's motion to quash the show cause order and or to recuse Judge Glanville. And 3. Defendant Jeffrey Williams' motion to disqualify, this is a big win for Steele, and recuse Judge Glanville from all further dealings in the above referenced case in amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. These recusal motions arise out of a multi-defendant prosecution by the Fulton County District Attorney's Office, alleged gang activity, and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to the state's witness, Little Woody. On June 7, 2024, the state intended to call Little Woody to testify. There we have a footnote. Prior to this testimony, counsel for Little Woody, Jonathan Melnick, appeared and indicated in open court that Little Woody did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Little Woody into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Little Woody. Judge Glanville specifically advised Little Woody that if he invoked the Fifth Amendment and refused to testify, the state would ask for Little Woody to be held in contempt and jailed. Judge Glanville also advised that, if asked, Judge Glanville would jail Little Woody for refusing to testify. After that discussion, Little Woody spoke to his attorney and then indicated he would testify. Once called, Little Woody was asked to specify his age, and instead of answering, he said, "I plead the Fifth." Judge Glanville excused the jury and then advised Little Woody in open court that he was in contempt and ordered him jailed until Monday, June 10th, 24, at which time Judge Glanville told Little Woody they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke with Little Woody and then reiterated to the court that Little Woody still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Little Woody on Monday, June 10th at 8:30, and court was adjourned for the day. On June 10th, 2024, at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Little Woody, Kayla Bumpus. The meeting took place in Judge Glanville's rectangular chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Miss Love told Judge Glanville that she wanted the meeting to both impress upon Little Woody the risks of refusing to testify and allow Little Woody to ask questions before he testified. Miss Love also expressed concerns to Judge Glanville about Little Woody's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity. Little Woody was then brought into Judge Glanville's chambers where he spoke with and asked questions of Miss Bumpus, Judge Glanville, and Simone Hilton, counsel for the state who had joined the meeting. During that time, the state advised Little Woody that he could remain in custody until the conclusion of the trial of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA Section 245507 with Little Woody and his rights and responsibilities after a grant of immunity. Little Woody spoke privately with his stand-in counsel, Miss Bumpus, and then advised the court that he would testify.
And let's stop right here. What does it say? Mr. Copeland spoke privately with his stand-in counsel, Miss Bumpus.
After meeting and immediately before Little Woody was brought to testify, defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the secret meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams, ultimately, Little Woody did testify on June 10th and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by Diamante Kendrick, shout out to Doug Weinstein, on June 12, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14th of 24, Judge Glanville denied the motion. Judge Glanville determined that the recusal motion was timely, you all remember that, supported by an affidavit, and on the cursory review contains assertions of fact to support the allegations of bias and impartiality. Those were the 3 parameters he needed to look at to make a ruling on whether he should recuse himself. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. On June 14th, Kayla Bumpus then filed a motion to quash the show cause order or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from a disclosure from the ex parte meeting. On June 17th, Young Thug King Slime filed his motion to recuse Judge Glanville. Discovered from this hyperbole, Young Thug's motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Young Thug also alleges was improper and coercive. Young Thug's motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Little Woody, and Judge Glanville became embroiled in controversy, quote unquote, when he held Young Thug's lawyer, Brian Steele, in contempt. On July 1st, 14 days ago, the court appointed for the parties to review a redacted transcript of the ex parte meeting. Judge Glanville announced that he was releasing the entirety of the transcript in the secret meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for the ex parte meeting. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville revised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the secret meeting or the nature of it. Judge Glanville also questioned the defendant's right to be present at the secret meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25-1 through 25-7. The motions to recuse were then assigned to this court for consideration. Now, the judge's argument, okay? So, motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion, we know that, supported by an affidavit clearly stating the facts and reasons for the belief that the bias or prejudice exists. The affidavit must be definite. Once and such motion is filed, it is a duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in a proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or the other interested parties. Yeah. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a bias for recusal. Here, Judge Glanville had previously announced on the record that motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment on the propriety of the ex parte meeting. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the secret meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Whoa.
Wait. What now? Read that again.
Yeah, she says, while the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper.
However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, Judge Glanville did add facts, provide context, question the veracity of allegations, and otherwise explained his decisions and actions and argued why those were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on the recusal motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal.
This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Based on the foregoing, this court hereby orders the following. 1. Defendant Diamante Kendrick's motion to recuse Chief Judge Ural Glanville is granted. 2. Kayla Bumpus's motion to quash the show cause order and or to recuse Judge Glanville is denied as moot. 3. Defendant Young Thug, King Slime, Brian Steele, their motion to disqualify and recuse Chief Judge Glanville from all further dealings in all the above referenced case as amended and supplemented is granted. 4. The clerk of court shall reassign this case using the court's case assignment procedures. It is so ordered on this 15th day of July. The Honorable